Appeals Division 1 is now in session.
Please be seated. This is the time scheduled for oral argument in our case, number 1, CV150126. CR2 Solar et al., the Arizona Department of Revenue in Maricopa County. Each side has been allocated 20 minutes for oral argument. The appellants may reserve time for rebuttal, but the clock in the podium will indicate the time that you have left, including your rebuttal time, so you would need to manage your own time accordingly. To assist you, you should be aware that we have read the briefs, we've read pertinent case law, we've looked at the record, and we've conferenced this case. So we're relatively familiar with the issues, facts, and law. While you've been allocated 20 minutes for oral argument, you don't need to use it all. If you're done speaking and we don't have any further questions, feel free to sit down. Also, you should be aware that we're recording these proceedings, both audible and video recording. So when you first approach the podium, please clearly state your name and who you're representing. And if you want to, within several days after oral argument, you can go on YouTube and watch the argument. So, counsel for the appellants.
Thank you, Your Honor. Good morning. For the record, my name is Paul Mooney. I'm here with Bart Wilhoit. We represent the plaintiffs and appellants, CR2 Solar, Mesquite Solar, and Perrin Ranch Wind. I will try to save 5 minutes of my time for rebuttal. May it please the court. The issue before you in this case is whether the trial court committed reversible error in interpreting ARS section 42-14155 as including in the costs to be used to calculate the full cash value investment tax credits, cash grants, and other similar types of rebates. We believe that trial court committed reversible error in this case for any of 3 different reasons. First, we believe it's clearly wrong because the statute was amended and in effect prior to the date taxes were levied, and therefore the new statute very clearly does not permit the inclusion of investment tax credits in the valuation. Second, we think it's wrong because the amended statute is very clearly a clarification of the prior law in that it merely added definitions to an existing statute to define this particular issue in more detail. And third, we believe it would be wrong even if you were to interpret the language of the original statute in accordance with the applicable canons of statutory construction. I'll cover each of those points to the extent your questions don't focus me in a particular direction briefly right now. They're adequately briefed. I don't think I need to say a whole lot.
I had a question, Mr. Mooney, up front. The federal tax credits and cash grants deal with facilities. So when I looked at the federal statute, it covers a wide variety of things in the facilities that were built. Whereas the Arizona statute we're dealing with deals with renewable energy equipment.
Correct.
And it wasn't really discussed in the briefs, but in terms of the offsets, the tax credits and grants for the facilities, how does that relate to then the depreciation for equipment only in the Arizona statute?
It's a great question. In particular, if you look at how these facilities are operated, 2 of them operate on leased land. 1 operates on land that's owned. So you have both situations. And you're right, the facility as a whole is what qualifies for the credits under federal law. However, the credits are tied to installing qualifying renewable energy equipment. In other words, it has to be a system that allows a non carbon-based fuel to be used to produce energy. In this case, wind and solar are what we're talking about, and in Arizona, that's predominantly what we have in the way of renewable energy equipment. So the statute is valuing the cost to the party developing a facility that qualifies. If it qualifies, they get a 30% tax credit that's a refundable credit, or a cash grant in lieu thereof. In the case of Parent Ranch Wind and Mesquite Solar, they both opted for and were successful in obtaining cash grants, although as it turned out they got reduced slightly because of government sequestration during the process that this happened. But it was based initially on a 30% reduction that actually ended up being slightly less than that in those two cases. In the case of Siete Solar, Siete qualified by using the investment tax credit, so they got the full 30%. They qualified by virtue of the fact that they deployed qualifying equipment that was used to produce solar energy, or in the case of the wind plant, to produce energy from wind.
But the costs then that were reduced, the adjusted cost would include more than just the cost of the equipment, right?
No,
No?
it would not. Because
Okay.
in the case of Mesquite Solar, which is the only one located on fee-owned land, the land is owned by actually a parent entity that owns the land and leases it to Mesquite Solar. So technically what I said a minute ago isn't even accurate. They're all leased facilities. So in effect, what is being acquired is the equipment placed on land, and it is the equipment that is what qualifies for
Okay.
the rebate.
I understand. Thank you.
Under the first prong of our argument, we know that this amended law would very clearly exclude investment tax credits and cash grants. It's explicit. We also know that that amended law was enacted in April of 2014. The 91st day following sine die adjournment of the legislature was July the 24th, 2014. The law had no specified effective date in it. And in the absence of a specified effective date, a law goes into effect on the 91st day following adjournment of the legislature. So on July 24th, 2014, the amended law was the law in Arizona. The levy and assessment of taxes under Arizona law did not take place, as it never does, until the third Monday in August of 2014, which was August the 18th, 25 days after the new law went into effect. In the Waddell case, on analogous facts, we had the very Department of Revenue, who's opposing the plaintiffs in this case, argue successfully in front of the tax court that a law that went into effect on June the 3rd, prior to the levy and assessment date, which at that particular time was, I believe, the first Monday in August. Laws have changed a little bit in that respect since 1991, that law should be applied. And the reasoning that they gave to the tax court has been quoted.
About jettisoning the reasoning that the department gave in briefs that are almost as old as I am, and talk about the decision of the tax court, because that's what
Sure.
is relevant, not what
Sure. And what-
someone argued 20 years ago.
Well, the bottom line is the holding of the court is this. The court holds that whatever property rights as may exist in a means of measuring a tax belong exclusively to the legislature. The legislature can change the standard for measuring a tax as it sees fit. And then in continuing on the next page, it then goes on and says, the decisions in which the taxpayers claim their rights were vested, which the court rejected under Hall and its progeny, are not yet final, because there were timely appeals filed, just as there are here. Even if they were final, the legislature could change them when the change in the classification standard became effective because no tax had been paid. Indeed, no tax had been assessed. The legislature has the power to make changes in the classification standards at any time. It can do that as long as it doesn't make them retroactive. There is no legitimate argument that the Department of Revenue can posit that this is a retroactive change, or that the Department of Revenue has some vested right in the mechanism by which values are determined. In fact, the Department of Revenue is supposed to implement the law, not make law. They're not supposed to interpret the law in a way that's contrary to what the law says. So I agree with you, Judge Norris. You're right. What they said in their briefs was this isn't retroactive. It's merely an application of the then existing law. And
Waddell involved a change in a classification.
it did.
And our situation concerns a valuation.
It does.
And we have other statutes, and I can cite them, but I'm sure you know them as well as I do, that peg a valuation date. They define, for example,
Sure.
that property will be valued as of a date, basically a descriptive date certain.
Correct.
Those statutes weren't amended, so is that a significant difference?
No, because those statutes under our current system set a valuation date which proceeds by 1 year, the day on which the tax lien arises, and it's an inchoate lien at January 1 of the tax year. But until the tax is levied and assessed, which doesn't occur until the third Monday in August by law, and that's still the law. Now it's codified in 42-17-151. It used to be 42-304. But the law is still the same. Until there's a levy and an assessment, the legislature has the power to tinker, to make changes with how a value is determined. And we're talking about how a value is determined for tax purposes. Classification is merely one component of what goes into the calculation of the final tax bill. So I believe that's clearly the correct answer. What I find offensive in some respects in having to even argue this case is, I can't quote the Latin maxim about not breathing hot and cold, and I don't care whether you use that phrase or whether you use flip-flop or whether you want to call it double dealing or whether you want to call it hypocrisy or duplicity or even judicial estoppel. I don't care what label you want to affix to what the department is doing here. It's wrong. The Department of Revenue is seeking to interpret the statute in a way that will maximize tax revenues. That's contrary to the canons of construction that apply, irrespective of the calendar dates that we're looking at in this case. And so I'm offended by the notion that we should even be litigating this case, in particular because if this statute is a change to the law, which it is not, I submit it is a clarification, and I could cite you your own case in Phoenix Cement, which came out since we were last here, since we briefed this case. You made it very clear that an amendment which in effect construes and clarifies a prior statute will be accepted as the legislative declaration of the original act, and that's the Supreme Court in the Killingsworth case. And the GM case says the same thing, and the Police Pension Board case says the same thing, and there's a dozen other cases that say that. And what we have here is a legislative amendment, which if you simply look at how the amendment is structured, all that got changed in the original statute was the addition of definitions. What is a more basic clarification than adding definitions?
I understand your argument. The question I have, though, is the version of the statute that we're dealing with was a 2008 statute.
Correct.
And those federal tax credits and grants, they weren't passed till 2009. So I'm having trouble understanding why we would have this adjusted cost idea in mind and have these federal credits and cash grants when those federal laws hadn't even been passed under this version of the statute.
Because it's well settled in our law that you don't get to count as a cost, that you get to depreciate something you didn't spend. If I tried to file a tax return with the Internal Revenue Service and said, I spent $100 million building this plant, but in reality I only spent 70 because I got 30% back from the federal government, and I tried to depreciate that investment based on a $100 million investment in cost, the IRS would not allow that. Nobody would allow that because I didn't incur the cost. In fact, this court's decision in the Salt River Project case, the so-called contributions in aid of construction case, also involved electric generation property, interestingly enough, although property owned by a public utility. And what this court said very clearly is that third parties who pay money to build facilities don't constitute cost for the utility. The utility doesn't get to count that as part of the original plant and service cost in that case. And the Department of Revenue wanted the utilities to have to include those costs as part of their total costs that they were subject to valuation on for property tax purposes. This court said no. This court interpreted, obviously, FERC rules and regulations in making that determination. But it's interesting, it was 4214-154, the statute immediately preceding this one, which specifies a net book value formula that's similar to the rate-based method.
Right.
And that's what the court said was, no, you didn't incur those costs, APS or SRP. Your customers did, and they contributed to them to you so you could provide service to customers. We're not going to allow you to include those as costs that you can earn a return on. But the Department of Revenue wanted to say, but we are going to count them as costs you incurred for purposes of valuing your facility on a cost basis. We're in the same position here. This is a cost-based statute where we're looking at the amount spent. And the department wants to say, well, it's the amount spent even if they got part of it back. That's silly. It's silly because it defies common sense. So even if we want to go leap to the proposition that the 2008 version of the statute is the one we're interpreting, and even if the legislature didn't know at that time that there were 30% tax credits in place because they weren't enacted until the next year, the simple fact is it's still up to the legislature to change the law if they want to change the law to exclude these things. What did they do when they were confronted with this question? Because, again, these are fairly new facilities. These are the first ones really that came online in Arizona were these facilities that we're talking about. What did they do when confronted with that? They amended the statute to define what the taxable cost was. And that's consistent with the original underlying intent, which was we want to encourage investment in renewable energy, green energy. We want to encourage this, and so we're going to give you a favorable valuation for tax purposes.
Couldn't you get, I mean, isn't it favorable to get the depreciation rates before the amendment, though? I mean, you could depreciate this property at 20% versus much higher rates of depreciation, even without the 2014 amendment. Under the 2008 law, you could depreciate that property first 5 years at 20% versus other statutes. I think it was like 35% the first year. And there's some benefit in separate and apart.
Clearly, the legislature intended to provide a significant benefit to people that would deploy renewable energy equipment in Arizona. Mm-hmm. That's unquestionable. We've cited that ledge history to you, and it's really unrefuted. There's no doubt that, indeed, other types of properties that are non-renewable energy facilities don't depreciate at as favorable a rate. No question about that. That doesn't change the fundamental underlying principle, which is that you don't get to depreciate something you didn't spend. I mean, if you didn't incur the cost, how can you depreciate it? It simply defies common sense. So on any of those three prongs.
Didn't the taxpayers here actually incur the cost and they received a credit subsequently? Or a cash payment?
That is how it works typically, because there's a lag between the time you spend the money and you can't qualify until you actually have a facility that's operating. And in every instance, these taxpayers reported to the Department of Revenue in the year they were assessable based on what their out-of-pocket costs were. I'm going to save what remaining time I have, if I may.
May it please the court, my name is McKayan Mahoney. I have with me Kenneth Love at council table, and we represent the Arizona Department of Revenue and the named counties in this matter. There are two major issues before the court. First, should the court apply the 2014 amendment to ARS 42-14155 retrospective?
I'm sorry, say that again? Should the court what?
Should the court apply the 2014 amendment to ARS 42-14155 retrospectively?
I'm sorry. I thought I heard you say the 14th Amendment, and I thought, wow, I've got to reread these briefs. Okay.
Isn't Miranda involved in this case?
I apologize.
That's all right.
Go ahead.
So where the legislature did not express any intent to do so, and second, under the pre-amendment language to ARS 42-14155, should the court exclude the value of taxpayers' tax credits and grants from determination of the depreciated cost of the equipment? The answer to both of those questions is no. First, the amendment should not be applied retroactively. Retroactively or retrospectively. Now here's, I think, where the major issue exists, is that in Waddell and all of the case law that plaintiffs cite, the legislature actually enacted an amendment with a retroactivity clause, or stated that the amendment applies as of an earlier date. Here, the legislature did not do so, and that's extremely important. The key to statutory interpretation is what the legislature intends to do.
May I stop you there? What troubles me about Waddell and your argument is, well, first, there's no question that's a big difference. No question about it. But the situations were different. In that case, in Waddell, the taxpayers were arguing they had a vested right. Thus, the retroactivity clause was ineffective. But the taxpayers here are really relying on a different aspect of Waddell, which is until I'll put it in my terms, the levy or the assessment occurs. The rubber meets the road, and we now have locked it in. The legislature may change the mechanism or the formula for the taxation of property. And until that happens, they can make a change. And so that's the point they're relying on, not the retroactivity point, but it's that point. So what's your best response to that point?
So my response to that point would be that they can. If here we had a legislature who said this statute is going to apply retroactively to the valuation date, when the department is supposed to value the property, then the legislature could have done that, and they've done that in many cases before.
So, if I understand what you're saying, if the legislature here had modified, in addition to this statute, if the legislature had also then modified the valuation, the definition of the valuation date, then they didn't take that step, and that's the step they needed to take for this statute to apply to really antecedent facts, not necessarily retroactively. That's the issue you're trying to say? Or,
Yeah, so because of the language, it's difficult. But
I know.
So the
Did you talk to our friends down the street at the legislature next time?
He's probably better at that than I am.
Okay. But, yeah, you understand
But-
my question.
Yes, and I think that's what the issue is. Here, the department values at a certain time. So it says the department must value these properties as of January 1st of the valuation date, which is the valuation year. That's not what the legislature changed. The legislature made a change to, the ARS 4214155, which talks about how you value property. But that valuation date, so the law in effect in that valuation date was before. The legislature didn't take the step to bring the law back or to rewrite history by essentially saying, okay, we're going to have this law go retroactively
That
back
I
to the...
understand, but I guess I'm still struggling a little bit because I'm not sure that solves my quandary. Waddell can be read for the proposition that until there is, in fact, a tax levy, the legislature can change the various component parts that go into the determination of the exact amount that the taxpayer will pay. It could be, for example, classification. It could be the valuation percentage, the assessment ratio. It could be, I guess, something else. And until the levy happens, those things are subject to change. And I don't see your answer responding to that.
So
or
they-
maybe I'm just not understanding.
So in Waddell, the statute was enacted with a retroactivity provision and an emergency clause.
Right.
So what they're essentially doing is they're rewriting history for that year and a half that's already gone by. And they're saying this law goes back to that date. And they can do that. And that's what Waddell says, is that they can enact a law, put a retroactivity provision in it to bring it back so that that date now becomes the date where the department is valuing property forward.
At any time before the tax is levied.
At any time before the tax is levied. But they didn't do that here. They didn't change the date when they didn't change the law back to the valuation date, which is what they would have needed for that to happen.
So there should have been essentially a subsection 3 that says, and furthermore, for purposes of the valuation of this property, we value it, I don't know when they would have done it, but they would have somehow modified the valuation definition of valuation day.
So there's two ways that they could have done this. They could have said, effective from January 1, 2013, this happens. Or they could have done, we apply this with a retroactivity
They could have actually
provision.
pegged the date on and after such and such a date, the property shall be valued using, okay.
Exactly.
In Waddell, they made it effective back to the tax year 1986.
Yeah,
That was
they put it back to the valuation date, the earlier date, and they said, okay, we're going to have that go
Actually,
forward.
even before the case in Waddell. They went
And-
back 3 or 4 years before that case.
And that's the critical part that you say makes all the difference here.
Exactly.
Okay.
Is this your language you're relying on? It's the very last paragraph in Waddell. The court states, since the legislation affecting the change in classification became effective before the 1991 property tax was assessed, and the legislation amending the statute clearly intended that it apply in 1991, the court holds the classification standard set out in the amended act applies to the 1991 tax year.
Exactly.
That's the essence of the case.
Yes, it may make such changes retrospective if it wishes to do so, and here it hasn't. And that's the distinguishing factor, I think. And that makes this different from Waddell or any of the other cases that have been cited. So
Do we have any other case other than Waddell that perhaps makes that point clearer?
Oh, sure. So if you look at the other case that they cite to, Martin,
I've read that. I was thinking more from Arizona.
so in the Arizona cases they cite, they all kind of are talking about statutes with a retroactivity provision. And I think we cited you quite a few of the statutes where the legislature actually does this. They go and they amend the valuation, the way the department values property, and they bring it back to the valuation date with a retroactivity clause. And that happens many times, and I think that's how we can understand that when the legislature intends this to happen, that's what they do. They go back and they change when the statute applies with the retroactivity provision. With respect to the argument that the department is arguing something different, again, I would just say this is why this is different. The department is not arguing that this is affecting a substantive right, because there is no substantive right. What we're talking about is the valuation date, which are two different things. Do you have a question, Judge Gisler?
Well, but there is law that says if you apply a statute to existing facts, it's not really a retroactive application. It's just applying it to antecedent facts. So why would you need a retroactivity clause if the legislature says, okay, as of this, here's the effective date of this statute. We're not going to include in costs these tax credits or grants. And we're just applying it to the facts as they exist now.
So ARS 40.
Mr. Mooney's nodding, so I think maybe it might be an important question.
For him, maybe. I think and maybe for you, I think the statute clearly states under 42.14153, valuations required by this section are the values determined as of January 1 of the valuation year. So the law and the facts in effect as of January 1 of the valuation year are where the department goes. The legislature tells the department what to do, and in this case, they've said, department, you have to do the values as of this date. And when they changed the statute, they didn't make it retroactive. They didn't say as of whatever, as of January 1, 2013, this applies. They could have told the department to do that, but they didn't. They just let it go into effect from here on forward. And I think if you look at the opposite side of that, of the question, you would say, well, when does the legislature have to say that things only affect prospectively if it only wants them to happen prospectively? Do we say these valuations will only occur from the next date forward? No, it's assumed that the legislature both understood that how the valuation statutes work, which is that as of the prior year going forward, that's what the value is, and that they knew that they could change it by making it retroactive, as they've done in many situations before. I want to get on to the next point, which is that the pre-amendment language of 42.14155 does not exclude the value of credits and grants from the department's valuation. Now, the department correctly valued the property according to its depreciated cost. So by amending the language of 42.14155 to use this taxable original cost, the legislature has really changed essentially how the department values the property, and that's a substantive change to the statute, and so it must be seen as an amendment that only applies forward, not as a clarification. So now we have to use a kind of a lopped off 70% of value if they've gotten this 30% credit before, whereas originally the department just valued it something at its cost.
Mr. Mahoney, let me ask you a question about how this amended statute came into existence. I thought it was surprising that neither party discussed at all the legislative history that gave rise to this statute. And doing some poking around, I noted that there was some discussion when this statute came through a strike-all amendment. And when it was before the, one of the, I think it was the Senate Commerce and Energy Commission in March 19, 2014. The parties that talked about the statute, Mr. Barnes and others, clearly identified, I think, if not this dispute, one just like it, as the reason why the legislature was being asked to amend this statute. Yet, you didn't rely on any of that to explain that perhaps this was a substantial change, not just a clarification.
I guess I would I'm not, I think that we did look at the statutory history and we saw certain things about it, but I'm not sure exactly what I'm allowed to talk about on that as far as.
No, I don't want to go anything that's not a matter of public record that could be used by a court in the normal course, such as legislative history. I just thought it was a little surprising that none of that was mentioned by either side. I don't know how it cuts, frankly. If, in fact, the legislature was aware of disputes of this nature and yet decided not to insert a valuation date change, one might think that cuts in your favor.
One would. Mm-hmm. I would agree with you there. And I think, so kind of, I didn't comment on it. I don't know.
Well,
maybe I should have, and I apologize.
Well, that's okay. Move on. That's okay.
All right. I think, again, we also look at the, so we would see that, yes, in our favor, that was a change to the law, not a clarification, because they didn't. They could have specifically said this is a clarification or made it retroactive, but they didn't. But even without that, if we look at what the plain language of cost of the equipment is, the legislature said the department needs to value this property at the depreciated cost of the equipment. And that's an important phrase. So what is the depreciated cost of the equipment? Well, the appellants try to rely on accounting definitions of what depreciated cost and costs are. But when you value property, what you're doing is you're trying to find the full cash value, in Arizona, the full cash value, or the value using standard appraisal methods and techniques. So when we look at this language, we have to look at how do you value property as an appraiser would, not how do you value this property on the books, in accounting books, because we're not trying to depreciate this property to get tax benefits off of it. What we're trying to do is actually find what another buyer and seller would buy in the normal course. So if I want,
we're not going to do the rich uncle hypothetical, are we? Now?
I'll use another one for you. Let's do Black Friday, right? So let's say I go today and I buy a 44 or 68-inch television screen for my house. And
a 58-inch television.
58-inch television.
No, we don't let that in my house.
Is it a solar television?
Yeah, right, okay.
Samsung.
Renewable?
Yeah, renewable.
LED, yeah.
Okay.
And so today I buy it and it's $1,000. But then on Black Friday I go in and I buy the same TV and they have a doorbuster deal where I get a $300 gift card back from my purchase of that TV. Does that make that TV somehow a different value because I bought it today versus I bought it Friday? No, the TV is still what it costs. You're getting an incentive back, and an incentive isn't taking the value off of something, it's buying a new one. Let's say on that Friday also I took that $300 gift card and I went and I bought a 327-inch TV for my bedroom. Well, does that mean that 27-inch TV was free, that no one would buy it from me, that has no value, no cost? No, it doesn't. The cost of something is what the cost is, what you pay for it. And here they paid the full cost, and then the department took that cost to base what the value of the property was. Then they depreciated that cost. So they took the cost, they applied a depreciation schedule, which they've developed for this type of property, and they took off, based on year, there's a depreciation in value. And that's what depreciation's, the plain meaning of depreciation is that you take off physical deterioration, functional obsolescence, or economic obsolescence. Here, none of those really apply. You have a cost, you have a depreciation schedule. The department applied the plain language of what those two words were to value plaintiff's property. Setting that aside, if we ignore what the plain language is and we go to the interpretation of the statutes under normal statutory construction, I think you would also use 4214156, which is what the department used to develop its cost approach for this property. And that's because this property is electric generation property. And so the normal depreciated cost, as the legislature put it, would be that cost as defined under 4214156, which is what the department values other electrical generation properties from. I think using the in pari materia doctrine, the reading all the statutes together, the legislative history, we can determine that actually the way that the department interpreted this statute, if it is ambiguous, was correct. I think there's a couple issues that plaintiffs point out about SEAC credits and how the department values the cost of property under Salt River, which is another case. I think that property was transmission and distribution property where the statute specifically said that you're supposed to use a form of accounting under 14154, so that does not apply here. And I also think, finally, that their constitutional argument is poor. And that's because, again, if I was to buy my TV today for $1,000 and I was to buy my TV, somebody else was to buy their TV on Black Friday for $1,000, but they got a $300 gift card, can the department value those properties differently under the statute because the costs were the same? So are we going to value their property differently just because there was some credit or grant versus what the property actually costs? So if there's no other questions, we respectfully request that you uphold the lower courts.
Thank you, counsel.
Thank you.
Let me move as quickly as I can and cover the couple points that I had. One of my clients is actually here in the courtroom, and he reminded me of something in response to an earlier question. I made the point that he made the point that the investment tax credit and the production tax credit existed prior to 2009. What didn't exist was the cash grants. Those were enacted in 2009, but the ITC existed previous to that. In fact, the ITC's been in the law for a very long time, and they modified it a number of years before the 2008 statute to increase it from 10% to 30%. So I did want to record to be clear on that. You know, Mr. Mahoney referred a number of times to this being a retrospective amendment. It's not. This is not a retroactive amendment. And the question that was asked a minute ago that I was nodding my head to, and I apologize for being so obvious in that, relates to the Tower Plaza Investments case that you were referring to, Your Honor, that a statute is not retroactive simply because it relates to antecedent facts. That's Tower Plaza. We cited several cases on that proposition on page 9 of our reply brief. And that, you know, there's 4 Arizona Supreme Court cases that make that point clear. What I think is interesting about one of the questions Judge Norris asked was about legislative history. Now, we did cover the legislative history of the original enactment in our opening brief, and that's 25 and 26. The amendment has virtually no legislative history, but it is interesting. If you look at the amendment and the definitions that were added, there were 2 things added that are relevant to this case. The first is the addition of the definition of depreciation in paragraph C1. That was added precisely because long before there was any of this litigation, there was a dispute. The taxpayers all filed their tax returns in these cases reporting their net, I'll call them their net costs. And the department said, no, we want the grossed up number. And so they had to report that, and the department used that number. But one of the issues that came up as we were going through the way these values were being determined, and in our complaint, which is in your index of record, I think it's probably document 1 or something very close to that, paragraph 8 of our complaint, we alleged, among other things, that the department's valuation of the property was excessive and inequitable because it was based on percent good tables that were not derived from the depreciated cost of the property, as mandated by the old version, 4214-155. Well, what that relates to is the fact that there was no provision in 4214-155, the earlier version, for adopting tables to determine useful life and straight-line depreciation. The department went ahead and developed tables anyway that they were using to value this property, and we were challenging that. So not only were we challenging the question of inclusion of the ITC, but we were challenging that. The process by which this legislative amendment was adopted addressed both of those issues, one of which inures to the benefit of the department, and one of which inures to the benefit of the taxpayers, to define and clarify how this statute, this term, depreciated cost, should be applied. And one of those additions was to allow the department to adopt tables, expressly legislative grant of authority, which didn't exist until it was put into this amended statute. And the other was to define taxable original costs as excluding these other items. So both of those changes are important, and while it's not legislative history per se, Your Honor, it is nonetheless indicative of, yes, the legislature was aware, certainly they were aware there was a dispute, because the process in Arizona is we value property a full year before it goes even onto the tax roll. And so in 2014, there had already been informal discussions between the department and the taxpayers. There had been an administrative tax appeal, all of which preceded the litigation that we're here about today. We never resolved any of those issues because the department insisted on including the tax credits. And
What about Mr. Mahoney's response to the questions we asked him, which, as I understand his response, that what's missing here and what distinguishes this case from Waddell is that there was not, the legislature did not basically peg the statute back to a prior evaluation date.
my response, and I'm over my time, but
That's
let me
okay.
respond to that. Let me respond to that question. My response is this. If you look at what was at issue in Waddell, you were dealing with a series of cases, the so-called Hayden Partners cases, and my office was involved in a bunch of those at the time, and they went back to the mid-'80s. And the reason there was a retroactivity clause put in was because there's a whole bunch of these cases that had literally been stayed pending the resolution of the Hayden Partners litigation. And the Hayden Partners decision came down, and then all of a sudden everybody came out of the woodwork and was trying to pursue those claims. And the legislature then said, wait a minute, we're going to put some standards in. It's not going to be this intent of the developer kind of rule. We're going to put in a rule that says you can't change the class until the foundations are in the ground. And that was the legislation that got adopted. And it affected a whole bunch of pending cases, some of which had been through prior administrative appeals, including for the year at issue. But what's interesting is, and we put the department's briefs into the record for this purpose, when questioned about that, the department said, no, we're not asking for a retroactive. We're not going back before 91. We're only going to 91 because the 91 taxes haven't been paid yet. And the court in Waddell says something very telling about that in this paragraph right above the one you quoted, Judge Gold. And they said this court need not consider what the effect of assessment or payment of the tax would have been, since when the amendments became effective, neither of those events had occurred. That's for the 91 year. But all the prior years as to which they could have gone back, DOR said in their briefs, no, we're not going back there. Because I think then you would have had a retroactivity issue and a vested right. Because taxpayers would have,
They've been levied.
they'd have been levied and assessed and they would have paid, and that would have created a very different procedural posture. And I apologize for going over my time.
No, it's fine. You were asked a question, and we let you finish it. We weren't going to say, no, don't answer the question. Thank both counsel for their arguments. We will take this matter under advisement and issue a written decision in due course. We stand adjourned.